So, as promised, we're going to pick up where we left off. We're going to talk about the special case of sex offenders because they are thought to be recidivists, that is, repeat offenders. And let's talk about the second goal, right? So the second goal is not to protect the community through notification, which was the first goal, but by extending incarceration. So the idea here is that one way to protect people is individual deterrence via incapacitation. Notice how those kind of overlap, by keeping them in prison or a state mental hospital for a longer amount of time. And the way this works then, if someone is classified, let's say a sexual predator or a violent sexual predator, and these label and classification systems are different on a state-to-state basis, but if someone is found during their time in prison to be a violent sexual predator and receive that classification, then certain states will allow for that person, once they've been released, they are sentenced for 20 years, they serve their full 20 years, if a clinician decides that they're still a danger to society, then they leave prison to be put into a state mental hospital where they are kept for treatment. But we already understand that treatment is not thought to be effective if we think all the way back to the beginning of the course when we talked about the case of Kansas versus Hendricks. Right? So here we have a clinician decides if the risk warrants involuntary commitment, and that you can think about in terms of Chapter 11 in civil commitment processes when we discussed it. Can they be committed to a mental institution? Right. And then their sentence, which isn't a sentence, it's a commitment to the mental institution, is contingent upon them no longer being in danger. That's a clinical judgment. So now imagine the power that clinicians have, psychologists have in this regard, of letting someone go or keeping them incarcerated. And what do you think? What is the motivation to let some nasty-ass sexual offender go? You know, this is a person who committed, let's say, some really heinous crimes against children, if you will, and it's like, yeah, we should probably let them go because I think they're okay now. Boy, talk about a risky decision, because if you hit it wrong, you're going to hear about it. So it's a tough situation at best, right? And I certainly wouldn't want to be the clinician making this decision. But then I'm not a clinical psychologist, so that's the way that goes. So when we want to determine the risk of reoffending, well, there's two ways that we can look at this. We can use actuarial judgments, and these come to us with a moderate level of reliability. When you think actuarial, I think insurance companies. And insurance companies have massive data sets, and they said, what is the probability of this person, this class of person, getting in an accident or whatever it is they're studying, and it's straight up statistical analysis, and it gives a probabilistic number, and that's relatively reliable. Obviously there's exceptions, but clinical judgments, on the other hand, is this one-on-one kind of judgment. We got a clinician with an offender, and the clinician looking at the offender's history and their current state, and then making a judgment call, and these are notoriously inaccurate, right? And psychopaths, you know, if we're talking a psychopath, they have a huge, tremendous ability to persuade, to manipulate, to present in ways that aren't necessarily real, and might, in fact, trick clinicians rather successfully. Right? And clinicians tie their skill to the ability to make these judgments, and then self-esteem issues, a whole constellation of self-related issues might make a person overconfident in making these judgments. Now, critics of this say, look, this is double jeopardy, because we've convicted this person, they served their time, but now we're detaining them, not right in a prison, but in a mental hospital, maybe a prison ward in a mental hospital, and it constitutes being punished twice, so call it akin to double jeopardy. And the Supreme Court came back and said no, because the second commitment to the hospital, you know, the first commitment to prison, if you will, it's not a commitment, it's sentencing to prison. When that runs out and then we civilly commit them to a mental hospital, notice that's two different stories, that's two different things, right? So it's not a criminal matter in the second case. But in all reality, if one's being confined against their will, what do we want to call it? But the Supreme Court said, hey, it's okay, it needs to be done. Right? So technically it's not meant to punish. That second commitment, that civil commitment, is not meant to punish, it's meant to treat. But if we have no effective treatments, then what are we actually doing? We're containing them, we're incapacitating them, and if the treatment paradigm is a real low probability, maybe 5% successful, means 95% of the time, pick a number, whatever number you want, you can see how some people will argue this kind of double jeopardy argument. Now, the third goal is to provide treatment offenders post-release. And what does this mean? Once we release people, do we make treatment available to them? Halfway houses, whatever kind of treatment is necessary to get them kind of on the straight and narrow. Psychological counseling is often a condition of parole in these situations, and this can be treatment on a daily or weekly basis, reporting to probation officers, etc. Some people suggest, castration is a good solution, and the problem with physical castration is, first of all, often these are not sexual crimes, but these are crimes of violence, exploitation, or crimes of dominance. So removing someone's testicles doesn't take that away, right? It might take away a sex drive, but if it wasn't a sex drive that's causing someone to commit these crimes in the first place, then we can see where that maybe isn't so effective. And the idea of removing someone's testicles is problematic in a lot of modern societies. I mean, that's kind of something that's over the top. So this is sometimes supplanted with this idea of chemical castration, and that is essentially some kind of hormone therapy, if you will, and just diminishing the sex drive in that regard. Is it effective? And that's obviously a question we need to ask. The evidence is mixed, but it works best when it's the offender's idea. So if the offender volunteers to take these chemicals, right, this medication, then it might work, but obviously if it's the offender's choice, sure, it's going to have greater efficacy. So the evidence is mixed on this. Now, let us move on to a discussion, a wholly controversial discussion of the ultimate penalty, if you will. Not counting torture, I guess, would be the death penalty as the ultimate punishment. And the death penalty has a long history across the globe, right? In 1972, the death penalty was declared unconstitutional in Furman versus Georgia. And some people say, yeah, death penalty was outlawed because it constituted cruel and unusual punishment, violation of the Eighth Amendment. That's not correct. Okay? It's not why it occurred. Why was the death penalty eventually declared unconstitutional? Because it was applied to too many crimes, right? So capital murder maybe should have been the crime, but then you start talking about other types of murder, you talk about rape, all these other offenses, kidnapping, applied to too many crimes, and juries didn't have proper guidance when applying the sentence, the death sentence. So it was really a hodgepodge mix-up of inconsistently applied penalty, and the Supreme Court said, no, we're going to step away from this. So state legislatures who are in love with the death penalty, right, rushed to fix these problems because they wanted their death penalty back. A lot of people are really big on death penalty, right? We got to kill these people, right? And because it's retribution. If you kill, then you have earned the position to be killed, right? That's the retributive kind of philosophy there. This is very potent in a lot of people's minds, as I hope we got in that first part. So everyone rushes to fix these problems, and it come to the Supreme Court again in Gregg versus Georgia. And what changed? Well, they made some modifications. Death penalty is basically for murder and murder only, so no other crimes basically at that point. And they set up this new process, this bifurcated trial process. And what that means is that we have the trial, and the jury first then deliberates to determine guilt versus not guilt. And if the jury says guilty, then there's more information presented about the nature of the crime, victim impact statements, etc., if you will, and then the jury goes back to deliberate on the sentence. And usually the choice at that point is life imprisonment versus the death penalty. So what it's done is try to separate the guilt from the penalty phase. And notice how important that was, especially when we were talking in Chapter 11 about civil trials, that people don't really do that effectively. So this was an attempt to kind of force that issue. So what happens? Aggravated and mitigating factors had to be specified by statute, and juries had to be instructed on them. So after we say guilty, we find the defendant guilty, then we're going to hear about all these aggravating factors, reasons the death penalty should be given. But then we're going to hear about all these mitigating factors that will be presented that should cause people to maybe back off the death penalty. So you might say, oh my God, look at the horribleness of the crime and the fact that the perpetrator tortured the defendant prior to killing them, etc. This is so heinous, they really deserve to die. And then, the defense will present a case saying, look, this perpetrator as a child was physically abused, they were sexually abused, they dropped out of school in the 5th grade, right? And they can't really be held responsible because of their poor upbringing, etc. And those would be the mitigating factors. And then the jurors are instructed on how to process this information. So aggravating factors would support a death sentence, could be future dangerousness, like I said, torture, was murder for hire, people don't look fondly upon that. The mitigating factors might be child abuse, mental illness, and family testimony. And the general formula as presented to the jury in their instructions that they use to assess this is the jury must unanimously agree on at least one aggravating factor, right? But the death penalty can be avoided if mitigating factors outweigh the aggravating factors. And I have a friend, we were in graduate school together, he was like 2 years behind me, John, and he left with his master's degree in social psychology. He moved back to California. He was from Northern California. Me being from Southern California, we always teased each other about that because there is somewhat of a rivalry between the North and the South there. Not huge, but he got a job at a law firm, and what did he do? Well, they handled the death penalty appeals in California, and he would do the background research. So he would interview people that knew the defendant, the convicted defendant, and try to make a case for mitigating factors. And he would gather all this information for the attorneys that were going to try and present mitigating factors in terms of the death penalty. So John spent a lot of time interviewing a lot of people, and he spent a lot of time at San Quentin, which is where death row was, interviewing the defendants themselves. So, that being said, let's ask about the death penalty. Why the death penalty? Well, it provides deterrence, a sense of closure, retribution. At least some people suggest that this is the reason, right? Is it true? Well, one of these arguments is subject to statistical analysis. We can ask, does the death penalty deter crime? And there's a couple ways to get at this. None are perfect, as in much research that's of this nature, so maybe it's best to use both. You can compare the murder rates in a state with and without the death penalty. And we don't see any difference in murder rates typically. So states that have the death penalty appear to have murder rates that are similar to states without the death penalty. We can also look at this kind of longitudinally, that is, compare rates when a state first abolishes, then reinstates the death penalty, and that is, over time, do we see a difference when the death penalty is present or not present? And then we can, make those comparisons. So that's one way to get at it. The other articles, the sense of closure, people, yeah, we can do survey research and garner people's opinions. That I didn't feel that, this was a closed matter until this person was put to death. Perhaps, right? The problem is now, but we don't really put too many people to death in a lot of jurisdictions, right? And the deterrence argument washes out completely. It's not a well-supported argument. Problem with deterrence, most murders are between intimates and friends. Like maybe about 75% of victims are killed by someone who knew them, and it typically is in the heat of the moment or the heat of passion, and in the heat of the moment people don't often reflect on the potential penalties of the action that they take, that is killing their friend. So the deterrence argument is probably the one that deserves to be explored. The others don't really support the issue. There's a fourth argument, and we can take it for what it's worth. Some people say, well, I don't want to pay to incarcerate this person for the rest of their life. I mean, that's just too expensive. We need to be done with it. And this is a specious argument because it costs more to put someone to death than to incarcerate them for a lifetime. So that argument just doesn't, I mean, it's a popular argument for some, but it's not supported by the evidence. It's more expensive to put someone to death, to go through the death penalty process, than it is to incarcerate them for life. So let's just put that one away as kind of nonsensical, although it sounds plausible at first blush. So, mistakes and biases within the death penalty, and this is why we kind of step back and question it for some of us, right? Some states have imposed moratoriums, right? And we have 87 people who are sitting on death row that have been exonerated by DNA evidence. And DNA has been a game changer, an official game changer. I'm not overusing that term here in this context. That is, we find many people have been wrongly convicted and facing the death penalty. Barry Scheck in the Innocence Project, right, does the DNA testing at the Innocent Project expense and finds often that there's a mistake, that we have the wrong person. Columbia University did a study on this, mistakes made in 2/3 of death penalty cases. Okay, what do these mistakes look like? Now, let's be fair-minded here. What we're saying is there's mistakes. Now, this doesn't mean that the mistake is game-changing, right? It means just that there were mistakes present. So mistakes made in 2/3 of the death penalty cases. That's 66%, right? Of those, how did the mistakes break out? Well, 37% had incompetent lawyers, and often if we have indigent defendants, right, who can't afford high-power attorneys, are appointed public defenders who are overworked and underprepared quite often, right? 37% may be incompetent lawyers. 19% of these cases maybe showed police misconduct. And 20% maybe had faulty jury instructions. And remember, we talked about jury instructions and the difficulty there. Now, the problem with jury instructions, the study by Lynch and Haney gave mock jurors comprehension tests to sentencing instructions. So let's put a frickin' study number to this. The average score, once people were given jury instructions and then given a test, right? And academic researchers are probably good at instructing and then giving tests, right? We see the average score was 16.4 out of 35, and that's a 47%, and 47% equals an E in any stretch of the imagination. Now, I understand during our pandemic semester here, you have the option to take courses pass, fail, or take them for the letter grade. But I'm telling you, 47%, doesn't matter whether you got a letter grade or a pass, fail. It still falls in the same bracket, does it not? So, results from those who supported the death penalty versus those who did not. Well, let's take a look at this. When we're confused, we rely on peripheral cues. And we're in the bastion of attitude research here at Ohio State. The elaboration likelihood model says there's two ways that we can be influenced to change our attitudes. That is central arguments that are data fact-driven, right, that we attend to and have to think a lot about. But peripheral cues are circumstances that don't really enter into the core argument. They're peripheral features like maybe attorney attractiveness, defendant unattractiveness, if you will, prior history as if it might matter, right? The deal is when we're confused, then we start to want to sort out our world, and we often rely on peripheral cues at that point. That is, we start to bring in information that isn't pertinent, that is irrelevant to the decision, but we use in an attempt to clarify our world and make a decision. So it could be the length of the presentation, and we talked about how that affects jury decision making. It could be the attractiveness. It can be race, right? That is perceived ethnicity. And if we use race as a peripheral cue, Lynch and Haney then in their study, half saw a black defendant in a mock trial, half saw a white defendant, all gave their sentence decisions, right? After the comprehension test, they split subjects by how well they've done. That is a high instruction comprehension group versus a low comprehension instruction group. And did the sentences differ for the two groups? This is a telling graph. So what we see here, and the term where the action is, we see three bars that are essentially identical. Where the action was is the bar that deviates. So let's unpack it here. This is the percent of the death penalty verdicts. And notice, when we have high comprehension subjects, that is those people who were tested for their comprehension of the instructions and did well on the test, earned a passing score, right? They both, whether the defendant was black or white, in fact, gave almost identical sentencing of about 46%. Right? Now, what happens when we have the low comprehension participants? Well, the white defendant got a minute decrease in the death penalty verdict, probably not a statistically significant difference. But what is different and what stands out here where the action is, when we have low comprehension subjects, what do we see? We see them rely on race as a cue in this. So, in fact, we see then a very high conviction rate, a conviction rate that's like 14% higher, or 14 percentage points higher than the high comprehension group. Questions about that? So again, when people don't understand, when they're confused, they start looking to factors to help them sort things out. And race is a reliable factor that many people will latch on to, and thus higher conviction rate for the blacks. So racial bias in death penalty sentencing. Chances for death penalty higher for killers of whites than killers of blacks. So now we go back to the kind of the victim perspective. That is, white victims earn or cause prosecutors to seek higher punishments. It's the prosecutor's discretion. It's not the juries that are doing this in this context, right? So let's look at a study of prosecutor discretion. This is the death penalty requests that were made, and this is something that's determined by the prosecutor. We want to charge with capital murder, and we want to seek the death penalty. If a white killed a black, we can see it's about 15%. But then if a black killed a black, it's about 15%. So notice perpetrator race was not figuring it into here. If a white kills a white, then it was up to 20%. But where we see the huge difference, right, is when a black killed a white. Then we see an increase. This is a 70% death penalty request. Questions about that? So these studies are very telling, and this is when we talked at the beginning of the course about Samuel Walker's book, right? Taming the System and the power of discretion in the legal system. This is where we have to be careful where we allow the discretion to occur, right? In this case, prosecutors have the discretion and they employ it to a large degree. Oops. Okay. So problems with death qualification. What the heck is death qualification? Well, it's the process. Do you have any extreme beliefs about the death penalty that would prevent you from being impartial about the death penalty? So I'm gonna out myself here. I'm gonna declare my bias right off the bat. I'm against the death penalty. I see no reason for the death penalty to be employed. Right? So if it's a potential death penalty case, what are they gonna ask me as I'm sitting there? They're gonna say, "Hey, Mark, do you have any reason why you can't do the death penalty?" And I would say, "Yeah, I can't do the death penalty because I believe it's wrong." And they would say, "Okay, you're dismissed. You will not be on the jury." Keep that in mind. I got a break here. We're going to come back for what? I believe it's part 3. So hang on.